Hello, this is JAA Your Way, and I am Jen Arey, Special Needs Navigator for the Jewish Federation of Southern New Jersey. And I am here today with Tony Serra from the Serra Law Group. Thank you for coming, Tony.
Well, you're welcome. Thanks for inviting me.
Great. Now, Tony has a law firm. Serra Law Group is up in now it's the Flemington area, is that correct?
Just outside of Flemington,
yeah,
White House Station. Yep.
Yeah, and just to let folks know, don't let that stop you from contacting him. He does cover the entire state of New Jersey. So,
correct.
Thank you for coming. I'm so happy to have you here. And this is such an important topic. Guardianship and special needs trusts and ABLE accounts are really something that can be very confusing for families.
Yes.
And can really cause a lot of complicated problems down the road if it's not done right.
Right.
So can you tell us, what is a guardianship and why should we have it?
Well, if you have a child who's disabled, it's cognitively, the issue is, when we turn 18, we're all presumed to be competent. So that's the issue is, if they're not able to manage on their own, what happens at 18? So the only way to address that, if somebody lacks capacity to manage on their own, is to have a court, make that declaration that they're no longer able to manage their own affairs. But I don't want people to get the wrong idea that you automatically need a guardianship necessarily if somebody is disabled in some way. There are alternatives, but guardianship is the process of convincing a judge that a person lacks the mental capacity to manage their own affairs. That's technically what that is. Okay,
excellent. I know we are going to get to those alternatives to guardianship, but I think it's important if we could kind of go over the process for that. So how does that work? What's the process for guardianship?
Right. Well, again, you may have somebody in the family, a child who is obviously lacks capacity, but you would still need two doctors under our court rules. You need two doctors to certify that. So the process involves a formal complaint to the Superior Court in the county in which you live, supported by these medical proofs. And these are two doctors that you need to certify to that. And by the way, one must be a medical doctor, the other could be a psychologist, a PhD. We can get into that a little bit more because sometimes it's advantageous to have a psychologist as a second doctor. But that application needs to be supported by a verified complaint, be sworn to by the petitioners, who in most cases it's going to be the parents, outlining the circumstances and what we call the objective manifestations of why someone needs a guardian, and then supported also by these medical proofs, these two doctor reports. You also need to submit a certification of assets indicating what the person's assets are and any income. And that's basically it. You file that with the court. The court will then appoint an attorney to represent at that point, the alleged incapacitated person, because they haven't been declared yet incapacitated. So in every case, in all guardianships, the court will automatically appoint an attorney to represent the interests of the alleged incapacitated person, because some cases it's not that obvious, and there's civil rights involved. So as part of the due process, the courts are protecting that person by appointing them an attorney. So unfortunately, it's an added cost. That's true, and we can talk more about that. Get a little further into this, but people should appreciate the role of that attorney, because the role of the attorney is to advocate for what that person wants. And the person may not want a guardian. The attorney may meet with their client, the alleged incapacitated person, and that person could refuse a guardianship. And so someone has to be their voice, and that's the role of the attorney. The attorney may not be able to defend the case, because the only way to really defend that case would be to get another doctor to suggest that the other doctors are not accurate. In other words, contest the medical decision that the person lacks capacities. And sometimes that happens. It happens a lot with older folks who are declining and on that spectrum, where maybe they've got some early signs of dementia, but they still have some cognitive capacity, and they may object to a guardianship. And that's where you get into possibly contested guardianships. But that's the role of the court-appointed attorney, is to advocate for the stated wishes of the alleged incapacitated person.
Okay, great. Now, you mentioned that there's costs that are involved. Right. So what are the typical fees that you would encounter in a guardianship that's not contested?
Well, the one obvious fee is a court filing fee. It's some counties I think are different, but it's around $175 to $200.
Mm-hmm. Yeah, I believe Camden County is $200.
It's $200, yeah. So the filing fee you always have. There aren't many other court fees at that point, but the court-appointed attorney will have a fee. Now, in our model forms now, you can choose to wait and have a pro bono attorney or a public defender, but that'll delay the process. But you have the option of doing that. But if you don't do that, and you want the case to move quicker, you have to check I'm okay with a private attorney and I'm willing to pay. Even if the alleged incapacitated person doesn't have funds, the court will impose that fee on the parents who are filing. So you have to be a little careful with that. Beyond that, there might be some fees. When you become the guardian, you have to accept that role and actually go to the surrogate and become the guardian, because the court order is just the court allowing you to be guardian. You have to now accept that role. Much like in a will, if you appoint someone to be someone's executor, they don't have to do it. They have to now go to the surrogate and be appointed and accept the role. The same thing with a guardian. So I think there's some fees associated with that, probably under $50 to actually become the guardian. And then legal fees, of course, but those are the out-of-pocket fees.
Now, are there additional charges to having a co-guardian? So if, say, for example, I get appointed as my child's guardian, and then a couple years down the road, I decide I need his brother to also be my son's co-guardian.
Yeah.
Is there a way to get that added on to kind of decrease the cost, or do we have to go through the whole process again?
Yeah, you don't have to go through the whole process, but you do have to go back into court. So in your scenario, if you want to add a co-guardian later on, you'll have to file another application for that purpose. But you don't have to go through all the medical proofs. So you're not dealing with the issue of whether there's capacity or not. But that other second person now has to be sort of overseen by the court and and vetted to some extent, and make sure that they're appropriate. That's why you can't put in a will, if I die, I want Johnny to be guardian for somebody, because it has to be done at the time that event occurs, that the court accepts that person as the guardian. The best thing to do, if you're concerned about, if you're elderly, let's say, and you're concerned that what happens when you pass, who's going to be guardian, is to be co-guardian early on with another child, somebody younger than you, so that if one passes, the other one can survive without any court intervention. You would want a co-guardianship up front, as long as you can work with the person, because then you have to agree.
Definitely, that can make a difference.
Right. You can have 3 people co-guardian, or you can have co-guardian with 3 people. But the more you have, the more potential for conflict over what to do when there's tough decisions have to be made.
Mm-hmm. So in that kind of situation, so then if my husband and I were co-guardians, then once my youngest son got old enough, we could have him be brought on as a third guardian when it's appropriate. Yes.
You may have to file, like I said, you have to file something. You can either do it by way of a motion, which is cheaper, it might be $15 or something like that, or they may require you to file another verified complaint for that relief, and that could be another $200. So if you're talking about cost, there's 2 ways to do it. Some courts will do it by way of a motion, or they'll do it by way of filing a formal complaint to allow that to happen.
Great. Now, what are some of the ways that families can do this less expensively? Because I know hiring an attorney and having them go through the whole process for you can create some significant costs.
Yep. It can, and that's what I do for a living, but I also know that many of these cases, especially if it's a child, go uncontested. So it's like an uncontested divorce. I mean, it's just a formality of getting into the court. And a lot of people do their own divorces, without attorneys. So I'm of the mindset that if people have the ambition and the desire to do this, they can file on their own. But you just need to have the right documents. You need to know what to file and how to navigate, that process. So we have on our website, we have this thing called Smart Law, which actually helps facilitate that, because I'm all for that. I mean, do I lose business? I suppose I lose business, but there's thousands of people who need this work. So it's not a question of me making money or not making money. It's really a question of accommodating people who are of limited means, who don't want to pay $2,000-3,000 or more, to hire a lawyer to do this. So one of the things we allow or we provide on our website is it's called Smart Law. And I think the cost is for like $750. You can interact with us and fill out a comprehensive questionnaire that we can use to then create your documents, almost like LegalZoom. But the difference between us and LegalZoom is we're a law firm. When you use LegalZoom, you're not using a law firm, you're using a form company, a big public company. So we're there to answer questions and navigate you through that. But if you invoke that process, you'll be asked to complete a pretty comprehensive questionnaire, which is good. And then we'll create the documents for you and show them to you, and you'll approve. And once there's a meeting of the minds in terms of the documents, and we'll give you instructions, you'll be able to take that package and file and get through the court procedure on your own. It's really what's called in the law now. It's called limited representation. Bundling and unbundling of legal services. The legal profession is 10, 20 years behind the times. Okay, this is happening in lots of other areas where you can hire professionals for certain things, not for everything. And it was always the case you hired a lawyer for a guardianship. Well, the lawyer did everything. I mean, that's what you hired a lawyer for. But today, among some of the innovative lawyers, that's not the case. You can hire lawyers today for specific things. As long as it's clear in the engagement letter what they're doing and what I'm doing as the attorney. And we make it very clear that we're preparing the documents for you. But once you get them and you're okay with them, then you're going to file pro se.
Right.
And your name will be on the pleadings, and that's fine. If you run into a jam, you just call us and we'll help you with it. But at that point on is when you represent yourself. And at that point, it should really proceed, arguably it's going to proceed uncontested. But if somebody contests it or the court-appointed attorney gets involved and raises issues, then you can always consult with us. But I'm really excited about that because I think the cost on our website, it's like $750 for us to prepare your documents.
Yeah, it's one of the lowest costs around to actually use an attorney in this process. So you'd have the $750, you'd go and you'd file, which would be about $200.
Right.
And then you would have the court-appointed attorney who would come and they would represent your child or represent the individual that you are applying for guardianship of. Is that correct?
Yeah. Since I, as the attorney, my name's not on the pleading, so they're going to be instructed to contact the parent directly.
Okay.
And they'll want to meet with the child, and the parents can be there or not, depends on what the attorney wants to do. But then they'll engage the parents to help facilitate that relationship. But the attorney at some point has to meet with the child, either with the parents or alone. But obviously they have to meet the child and see what their client wants. And in most cases, the client, if it's an 18-year-old, with autism or with Down syndrome, they essentially consent to it. It's more the issue. It's going to be more the issue. And this is a tough spot. This is a tough issue. It's more the issue that parents are asking for a full guardian, a plenary guardian, when the court-appointed attorney may feel that their client has more capacity than that, which raises the question of whether there should be a limited guardian instead of a full guardian. That's
a great point.
Yeah.
Can you go into that a little bit more? What is a limited guardianship?
Well, a limited guardian is essentially what it implies is that it's not a full guardian. It's you are guardian over only certain decision making. So if you look at the general areas of decision making, there's the legal issues, there's medical issues, there's residential issues, there's financial. I mean, there's 5 or 6 large areas that the court looks at. But a child may be able to determine or decide where they want to live, given certain options. Obviously, I'd like to live in Hawaii too. But if that's not an option, but within the range of options, realistic options, a child can make that decision. Or a child may be able to be employed in certain areas, but they can't make medical decisions. Or when I say that, I mean anybody can follow the advice of a doctor, but to make an informed medical decision requires you to understand what the doctor is saying, understand what options are, there's different ways to treat different things, and make an informed choice. I mean, well, he can make a decision. He just listens to what the doctor says. Well, that's not an informed decision. You can choose to do that, but you're making a choice to do that. So you may get someone who lacks the ability to make an informed medical decision, but can decide, again, generally where they want to live or employment. So that guardianship would be structured. You have to work with the doctors, because the doctors then have to support that. So the doctors are going to come out and say, yeah, in these areas they have capacity, but in these they don't. And that's not easy, because you have to feed information to the doctors, because it's a legal issue and a medical issue. But there's a way to do that. So the order coming out of that guardianship would be a limited guardianship, and it would specifically state the areas where the ward retains authority, and the areas where the guardian assumes that authority. If it's done correctly, that's what it'll look like.
Yeah, health can definitely be one of those key areas. Typically for myself, what I've heard in the past is limited guardianship in reference to financial and health.
Yeah.
And
right.
As we all know, a lot of our children and family members with disabilities, they can have very complex medical needs, and sometimes even we struggle with trying to keep it all straight and understand what our options are and how to best approach these things. Yeah. And it can definitely be a significant area of challenge for an individual, and so limited guardianship is a great option in those cases.
Yeah. And if the parents are up to that, but a lot of these parents who've taken care of their children, their disabled child, and they want that full authority, and it's understandable. But to get back to my original point, is that the court-appointed attorney may raise that wait a minute, I think this child is telling me that they want to do certain things, or I think intuitively I can see that they have some capacity. They may bring that up, and so the parent should be aware of that. That discussion might happen.
Definitely. Something I also hear a lot from parents, and especially those who are perhaps less in favor of guardianship. Can you kind of explain to us a little bit more about how an individual's civil rights are impacted if they have a guardianship? Yeah.
Well, they're impacted in the sense that most decision-making cannot, if it's a plenary guardianship, a full guardianship, then really all decision-making is taken away from them. In the right case, done the right way, it's a liberating experience, actually, because presumably the person can't make decisions. So by giving them a guardian, you're giving them a voice, if the guardian is acting correctly. Because the standard for a guardian to make decisions is not just what they think is best. The standard for a guardian making decisions is best interest based on what they think the person would want. So in theory, guardianship is actually liberating if it's done correctly. But you are still removing the decision making away from that person and giving it to another. So that's where the civil rights comes in. Interestingly enough, in a typical guardianship, a plenary guardianship, without anything more said, the person still retains the right to vote and to marry. It has to be specifically stated in there that they lose those rights. But other than those two rights, it is a stripping of someone's rights to privacy, rights to make decisions for themselves, rights to decide who they want to be involved with. I mean, it's very restrictive. I mean, it can be, especially if the wrong person or if the guardian is not acting ethically, and that's a big issue.
Yeah, it's a huge consideration when you're considering guardianship for your child or your loved one with a disability. You really want to kind of look at all the potential ramifications of it and decide, like you said, maybe a limited guardianship is more appropriate, or one of the other interventions and steps that could be taken instead.
The lesser restrictive alternatives.
Absolutely.
Right.
Yeah, what you said.
I think it's on our list to talk about.
It is. In fact, that's our next thing. Okay. Could you tell us what those options might be?
Well, the obvious option would be if they can, sign a power of attorney or a medical proxy, and if, for instance, if a child turns 18 and now can no longer access the medical records or school records, which is true, the person can simply authorize that. The child can authorize the parent to do that, if they have the capacity to do that. Now, if it's someone who is clearly lacks capacity, then obviously they can't give consent for that.
Right.
So that case you need a guardian. But if it's someone on a scale who's mildly, cognitively impaired, they may have the capacity to sign a power of attorney. And as an attorney, I know what that capacity is. Is that, are they aware of what they're signing? Are they aware that they have the right to stop someone from are they aware that they can give somebody the right to act for them? Mm-hmm. And are they aware of who that person is? Do they trust that person? These are basic, they're fairly low level standing of what it takes, fairly low level of what it takes, capacity of what it takes to appoint somebody. You don't need to be ready for jeopardy to do that. So someone may have the capacity to do that, and then that would be a less restrictive approach if what you were looking for is gaining access to medical records. And it could serve the purpose long term if all you need is the authority to act for somebody. Where a power of attorney wouldn't work is, one, they didn't have the capacity to do that, obviously. They couldn't even meet that low standard. But two is where what I call there's hostility between the two, where they want to make certain decisions that you think and is not in their best interest. And that poor decision is a function of their lack of capacity. We all make poor decisions. It doesn't mean that those poor decisions mean we're incapacitated. It just means we make stupid decisions. But if a poor decision is a function of the lack of capacity, then that's that nexus you need to show. Then that would trigger a problem with the POA, because now they're doing things that are spending money and gambling, or it might be a drug issue. Something is occurring that you want to stop. The POA is not going to work because they can revoke it right away. Mm-hmm. So they can revoke the POA. So in that case, if you think they're making poor decisions because of a medical condition or a psychological condition that's rendering them incapacitated, then you would need a guardianship in that case.
So if something was to happen, say one of these unfortunate circumstances, maybe they sign a loan for something that they just don't have the money for, or they rack up some fairly significant credit card debt, right, and it's all because it can be proven and demonstrated, right, that it's due to their limited capacity, right, and you only have a POA. Do you have any recourse at that point without the guardianship?
That would be, that's a risk you take. If they signed a power of attorney and now a year or two later the situation occurs, they rack up this debt because they were taken advantage of, that you would argue is a function of this lack of capacity, you can have a tough time with that case, because the creditor is going to say, well, they signed a power of attorney. I mean, you yourself acknowledge they had capacity, and now you're saying you just don't like the deal because you don't like the deal. That's you're going to have to try to challenge that and show that later on that at some point when this issue comes to a head, you're going to have to try to prove that they lack capacity at that point, which is probably a higher level of functioning than the POA was, but presumably, they were competent when they did that. So,
And this could be especially important if somebody has like a progressive condition,
right?
And maybe 2 years ago they were
right,
very capable, and the POA was absolutely appropriate.
Right.
But maybe 2 years later their condition is worsened,
right,
and now it's time to look at that guardianship.
Right. Yeah. Well, they got now they got taken advantage of in some way, but there are risks involved. That is true. I'm not going to say there isn't, but whether that warrants a guardianship or not, is a decision that the parents need to make. I think, in my experience, a lot of times that doesn't always occur. I don't know why. If I would advocate for a guardian necessarily to forestall that scenario, it can happen, and I think with an aggressive approach, you might be able to undo these things. I'm just trying to weigh the benefits of, that, trying to stop that from, a relatively restrictive approach like guardianship. I'm really a social worker at heart. I'm a proponent of less restrictive approaches.
No, that's great.
Yeah, so I mean, it's I would err on the side of Because especially with a young person, you say, well, a young person over time may actually get worse or have more diminished capacity, but usually it's the opposite. Usually over time they mature and they do better. And now they're straddled with a guardianship, and the message you're sending to them is they're inadequate, and so you don't want to send a message either that hurts them.
And that's exactly right. It can be incredibly hurtful, especially when we have spent all these years trying to build their confidence, build their skills, and tell them what amazing, wonderful people they are.
Right.
And now all of a sudden you're asking them to consent to something that says, oh, by the way, you actually aren't.
Exactly.
And that can be a very difficult thing to have to do.
Yep.
And we want to empower them as much as we can.
Right.
Obviously, we want to protect them,
Right.
But if we can, and the options available to give them those rights and give them those options, we absolutely should. But I know as well that I just wanted to touch on real quick before we move on to our next topic, but the timing of getting your guardianship is incredibly important. I had a family who reached out to me just last week and were telling me about how, her daughter's 20 and she goes to CHOP and she's, getting ready to transfer to, a doctor, and they lost their insurance cards.
Oh, wow.
And she can't get new insurance cards for her daughter because she doesn't have a guardianship. So unfortunately, she's in this situation, but in an ideal world, what would the timing be for our families so that they can minimize the problems that they might run into?
Well, you want to try to get it close in time when they turn 18. So there's usually a 2-month lead time in terms of how long that process takes. So I just know from my experience, if I have the doctor reports in my hand, because usually it takes a long time to get the doctor reports, that usually what delays these things. But once I have the doctor reports, then I can file. That is probably around 2 months to get the final hearing. So you want to go out about 2 months. Now, some surrogates might accept you sooner, might accept the application when they're actually 17 or 17 and 8 months or so. But I would look to file, at least 2 months before they turn 18, so that the final order is going to coincide with them turning 18.
Great. I think that's important to remember because, again, it's so important that the law legally, they are an adult, and if they need you to intercede on their behalf,
right.
We really need to make sure that we have those pieces of paperwork in order.
And not minimize that gap.
Absolutely.
Yeah.
It's so important.
Now, if you're late in filing, or in your case, a 20-year-old, you can file and get a temporary guardian too. The law, some of these things change. I mean, the temporary limited guardians, when I first practiced 30 years ago, it was none of this. It was all or nothing. And the law was so behind the medical field. I mean, the medical and psychological field was obviously people have a spectrum of capacity. It wasn't all or nothing. But for up until the last 15, 20 years, it was all or nothing in the law. But recently, I say recently because the law works very slowly, you now have limited guardians. It's statutory now. It took years. There's a case from years ago, the MR case, and the Supreme Court said, we should have limited guardians. But it took the legislature, years after that to actually codify it. But you have limited guardian and you have temporary guardians. So you could file immediately, and if you could show the court there's a need for an immediate guardian, maybe to access health insurance or do something, they can appoint somebody, what's called pendente lite. It's it's a legal term for somebody pending the litigation, to do certain authority, give them certain authority until that case is heard on a final hearing.
Okay, great. Now let's talk about trusts. Because trusts are very important. They're another piece to your whole estate planning, financial planning, and usually at the same time you're thinking about doing your guardianship. You're going to get your will done at the same time, and you should probably have your trust done as well. And can you tell us why that's all important to do?
Yeah, I mean, I'm going to go on a limb here and say anybody who has a child with special needs. And who's receiving or likely to receive, means-tested benefits, like SSI or receiving Medicaid, you need a special needs trust as part of the parents' estate plan. So in case something happens to the parents, any money going to that child is going to be going into a special needs trust, which protects those benefits. So that's what a special needs trust does. And again, that was, for years we never had that. And then people would just inherit their disabled child and give it to the other children in hopes that they would take care of the disabled child. And it probably works. I mean, I'm not saying it doesn't work, but that sort of ignores the issue. The issue is, if you have 3 children, they should, and you like them all, I mean, they should all get 1/3, but that child should also get 1/3. And the statute was changed in the mid-90s to then allow these special needs trusts to be created. So the parent should have an estate plan, and the money that's earmarked for the disabled child should be earmarked to a special needs trust. Although it's called a supplemental benefits trust if it's going to be third-party money. So
Can you go into that a little more? That's confusing.
Yeah. It's generally referred to as special needs trust. These are, again, instruments that allow a person to have the benefit of access to funds. It's limited, but it's access to funds while still maintaining their means-tested government benefits. That legislation was created back in the mid-90s. And it was really designed for the cases where, like negligence at birth, where somebody, received $1 million settlement, okay, an infant on their behalf. That money would go into a special needs trust so that when they turn 18, that those benefits the government benefits would not be interrupted. That was the genesis of that scenario. And those are called special needs trust because they're funded by the person's own money. Well, they don't have any money. Well, they do have money because they file a lawsuit and they receive money from a lawsuit. So that's what that statute really contemplates. But as a result of that statute, this idea of a supplemental benefits trust evolved. And now that is similar to a special needs trust, but the difference is it's funded by third-party money. It's not funded by the disabled person's money. It's funded by third-party money. So they're technically called supplemental benefits trust. And so people watching this who are trying to do estate planning with their own money want to set up a supplemental benefits trust for their child so that money, when they die, goes into that trust. It has the same effect of a special needs trust, but it's coming from a third-party money. The difference is when the child dies, the person for whom the trust is set up dies, whether there's a payback to Medicaid or not. Under a typical special needs trust where the person had a lawsuit, a medical malpractice suit, there's $1 million in the trust.
And these are what are commonly referred to as well as first-party trusts, right?
Yes, first-party trust, yeah. That will have a payback provision. So any money left when the beneficiary dies goes to Medicaid. Any money left then would go to the heirs of the person. But first, Medicaid wants its money back. The supplemental benefits trust that we're talking about, that everybody really should have if you have a disabled child, that's third-party money, and there is no payback to Medicaid when the person dies. So that's nice. So you could put in your trust, I leave it to my son Johnny, or it's in the name of the trust is my son Johnny, but when Johnny passes, it goes to his remaining siblings or his children or however you want that. And you could dictate that in that supplemental benefits trust. But there's no payback because it was never your child's money.
Now, what are some of the things that money can be used to pay for? Because SSI money has to go towards housing and food.
Right.
Are there similar restrictions to your trust money?
Well, the way it works is the special needs trust is intended to supplement and not supplant. That's sort of the catch term. Supplement but not supplant. So in theory, it should cover things that SSI should cover. So you're right, SSI, your monthly income, should cover your basic necessities and basic housing. And the special needs trust should then be used to enhance your living. Things like a wheelchair if you need it, or you need a computer, or you needed training of some sort. You want to go to a yoga class, I don't know, horseback riding.
Want to go on vacation.
Well, vacation, right. I mean, there's the degrees of these things. I mean, you can't go on vacation 50 times a year, but I mean, yeah, it's vacations. Things that will improve your life. And it should be used for that. That's what it's there for, you know.
Maybe your child is just totally enamored with all things Disney.
Exactly.
And at some point in their life, or maybe it's a tradition that you always had when they were little, was like every couple years you'd go to Disney World.
Yes.
And you want to continue that tradition
Perfect.
as they get older so that they can see all their beloved characters.
Yes.
And this would help allow for that to happen.
That's exactly what it's for, right. So should it be used for ShopRite every week? No. You got to have a budget. You got to use that money for that purpose. Now, if you have a special diet and you're beyond that, you need more money than that, then there are ways to structure that. But it has to be done thoughtfully and with those factors in mind that, you know, I need to eat special food, or, you know, I have other requirements that take me beyond my SSI. There's ways to do that. The same with housing. There's ways to supplement that with these trusts. But you have to be loyal to the concept that it's to supplement.
Absolutely.
And not take the place of SSI.
Yeah, and it's important to have those conversations, not just between yourselves as parents, but also with grandma and grandpa, because grandma and grandpa, they have the best intentions at heart, and they want all their grandkids to inherit, and they may have, you know, a $500,000 estate perhaps,
right.
And you know, that's going to get split among the 5 grandchildren, and all of a sudden your child who, you know, is getting Medicaid and SSI all of a sudden loses their benefits because now they have $100,000 to their name, and they get taken off their benefits. It took you years to get them. And it can cause huge amounts of difficulty and problems for these families.
Well, the SSI is one, but if you lose your Medicaid, that's incredible.
That's your doctors, that's your medications. Yes. It's so important to have this conversation with the entire family. And while those checks from grandma and grandpa in the mail for birthdays and holidays are lovely to get, that's also counted as income and could potentially jeopardize your child's benefits. So it's important to consider other ways that they might be able to help, and maybe funding an ABLE account, that might be an option for them.
Yeah, if it's a modest amount, it can be. Yeah, because I think they're limited to like $15,000 per deposit or something like that.
Yeah, per year. It's limited to the annual gift tax.
Let me make one more comment about the supplemental benefits.
Sure.
Because you raised the grandparents, that's a good point. If the parents set up this supplemental benefits trust as part of their estate plan, it could also be funded with other people's money. So you're right, they should be talking to the grandparents, and one of the things the grandparents should do is put in their will, if they want to leave it to this child, into that same trust. So money from different people can go into that trust. Just keep that in mind. They don't need their own special needs trust or supplemental benefits trust for that child.
Yeah, because that could get complicated if you have everybody with their own trust and it's all going to one person, and all of a sudden you have 5 different trusts.
Yeah.
That's a lot to manage.
And I've seen that, and the question then becomes, which one do you use? Yeah, that's how you do that. Yeah.
Now, what about...
One other thing too, though, because you also raised, if they forgot to do that and it went to that person outright, there are ways to adjust that. Well, first of all, if it's in that person's name now, they can set up their own special needs trust. So they're going to have 2. They're going to have a supplemental benefits trust that they got from the parents, but they may have to fund their own special needs trust with that money.
But that would it now be a first party trust?
Yes.
Because even though it's money that was originally from grandma and grandpa, all of a sudden now it's in their possession.
Right.
And it would have to go into the first party trust, which is the one that's subjected to Medicaid payback.
Yeah, because that person has to fund their own trust now with that money, because it became their money.
And that's important.
Yeah.
And it's also important not to forget those insurance policies, because insurance policies have their own separate beneficiaries named in them and are not subject to the dictates of the will.
Exactly. Unless you put as a designation, the beneficiary designation of the insurance, your estate. So if you're coming up with an estate plan that contemplates a lot of this, you would want your insurance to essentially fund that concept, then you want that money to go into that estate so that it flows, because a probate asset, and then it flows according to the terms of the will. But if you leave it to the children outside the will, non-probate, and you name them as beneficiaries, it's never going to get into that will. So that will's not going to control that. So that child's going to get that money and then have to set up a first-party trust.
Right. So you could have instead of naming all 3 of your children, you could name your first 2 children, and then your 3rd child, instead of naming their name, you could either say could say their special needs trust.
Yeah.
You could designate that instead.
Yeah, exactly.
And that would protect them.
Yep.
Yeah, great. So now, if we can get back to the ABLE account, can you tell us a little bit about an ABLE account and what it's meant for?
Well, I think it's meant for relatively modest estates where you don't want to set up a special needs trust and have special needs trusts are fine, but they are restricted and they're cumbersome in a sense. They can be expensive, although our Smart Law also, you can do through our Smart Law platform, you can do special needs trust for a relatively modest amount too. Mm-hmm. And our prices are all on the website, so you can go right to the website and see that. But it needs its own EIN number. It has to file its own tax return. There's issues associated with a special needs trust that may not warrant doing that if the amounts are relatively modest. And the ABLE account allows you to do that. And that money put into that ABLE account would not jeopardize your government benefits. But you are somewhat restricted in how much you can put in.
Right. I believe the limit is $100,000 before it starts to affect your government benefits. So if you have any amount of over $100,000, they will actually freeze your government benefits until you spend that down. So that's an important consideration. And it's also structured very similarly to college 529 plans.
Yes.
I believe that was what they based it off of.
Exactly, yeah.
Yeah, so if grandma and grandpa are putting money aside for all the grandkids' educations into 529 plans, and they started one for your child who has special needs, and realize later on that college may not be an option, I believe you can roll that 529 plan into an ABLE account. That's my understanding anyway, is that it can be converted.
Yes, I think you're right on that.
Yeah.
And it's nice too because then you can access it through debit cards. There's ways to use that money that aren't as restrictive as the special needs trust would be.
Yeah. First, is it first-party special needs trusts that you have to actually petition the court to use the money, or you have annual review, or there's some sort of oversight?
That first party, you're always subject to review, by Medicaid and those means-tested agencies, are always subject to, your accounting, to see your accounting. So that's why you have to be sort of loyal to that approach.
Right, so that makes it much more complicated, whereas with an ABLE account, you can just pull out a card that's attached to the ABLE account, and
a lot less oversight.
And you're all set.
A lot less oversight, yeah.
Yeah, it is definitely easier. Now, is there anything else that we maybe forgot to mention?
Again, I would encourage people on the guardianship piece to, see if they can do it on their own. See if they have the inclination to, and not be afraid to go to court. And a lot of these things, a lot of cases too, are sometimes heard on the papers, meaning they don't even require court appearances. A lot of these counties are doing these on the uncontested guardianships. Yeah, and I know too on the medical forms that the doctors need to sign off on, I believe there's a box on there that says that you can waive the need to have your child come to the court hearings because maybe it's a hardship for them. Maybe they have complex medical needs. Maybe it would be too traumatic or stressful or confusing for them. And it might be appropriate for them to actually not come if at all possible. And you can definitely select that option. Yeah, it has to be supported. The rules encourage the person to be there. The rules encourage that. So if the doctor is able to say, as part of their evaluation, that it's best that the person not appear, and then they can check that box. Yeah, and in most cases they do. The person is not going to get a whole lot, not going to be able to participate a great deal in that, and probably create more frustration for them. Absolutely, and that's why it's important, again, to have that attorney that represents your child, so that can all be checked and verified and make sure it's appropriate. Yeah, well, that would help. Yes, the court-appointed attorney would have a say in that as to whether the child should appear or not. Definitely. Yeah.
Well, it's been a pleasure, Tony. Thank you so much.
Thank you for inviting me and chatting with me.
Definitely.
All right.
All right. Thank you.
All right. Thank you.